The ACC lawsuits are always in the news, so we're back on the Big Mountain with a very special guest.
Hey, welcome back to the Mountain. I am JY. This is my good friend Steve, and as everyone can see, we have a guest with us. David McKenzie returns his second stint here on the Big Mountain. Very excited to have him back. We welcome you back to the Big Mountain, David.
Thanks for having me. Glad to be back.
Yeah, you can find David on X, McKenzie Law. You know, he's intellectual property, contract law. He's getting into NIL, media rights, all kinds of good stuff. But we want to talk to David here about the ACC lawsuits. You know, things have obviously changed since the last time we chatted a few months ago. And I want to focus my first question here on the media rights contracts and the grant of rights. So as everybody, I think, is aware at this point, we saw some of the media rights agreement that was released, very heavily redacted. But I've seen here recently some people on the socials kind of giving some opinions as to the existing media rights agreements and how they are defined specifically in the grant of rights. So they actually uses ESPN and some of the dates and things like that in the grant of rights. And again, like I said, they're tied directly to one another. And so some, like I say, have opined that because it's so specific in the grant of rights, this ESPN agreement, that if the ESPN agreement ceases for some reason, then basically the grant of rights ceases because what it's tied to no longer exists, and any subsequent agreements or changes would need to be ratified in order to maintain that specific grant of rights. Is that accurate? Is that not accurate? Can you help me a little bit understand that? Just to me, that seems so an easy way to blow up a grant of rights that I wouldn't think any drafter of the grant of rights would have allowed. But can you help me understand that a little bit, David?
Sure. I first want to point out that very little is known about the ACC ESPN contract, and so therefore, you know, what was produced was, I think, fairly described as a pile of or a mountain of redacted crap, and so little is known from that redacted crap, if you will, that the only thing that can really come from that is likewise is just not well-informed opinion. I mean, the contract goes over, you know, I think 135, actually it's over 200 pages. And you have the vast majority of it redacted, and what people on social media or in other forums are basically clinging to is one sentence, right? And but they don't know what the other clauses say or what the other sentences say throughout this very large document. And so what you're getting here is a lot of hocus pocus legal theory, I think, on what ultimately is going to happen with the grant of rights agreement. Now, I do think it's really and critically important for your listeners and viewers to understand is that the ACC ESPN deal and the grant of rights agreement, they operate in different legal spheres. They're not the same agreement. And what I think Clemson is trying to do, and then what I think what you, in your principal question, you were sort of assuming as a predicate is that, you know, if and when the ESPN agreement stops, therefore the grant of rights agreement, you know, goes away. Mm-hmm. Number one, as I stated, there are two separate contracts. They operate in two separate spheres. And the most critical reason why they operate in two separate spheres is because they have two separate parties to the agreement, which Clemson and Florida State are not for the ACC ESPN deal. The ACC ESPN deal is a contract between the ACC and ESPN. And at best, what Clemson and Florida State would be is what's called a third-party beneficiary to the ACC ESPN deal. Now, I won't get into what a third-party beneficiary, what their rights and obligations, or not really obligations is the right word, but, you know, rights may be. But what a third-party beneficiary status does not allow you to do is to take minuscule language like a linking verb is, which it seems that's what it's coming down to, and then somehow use that to create definitional terms in the grant of rights agreement. The bottom line is that the agreement governing the media rights, the copyrights, the intellectual property between Clemson and between Clemson and the ACC and FSU and the ACC is the grant of rights agreement. Now, in that agreement, it does say, you know, regardless of whether the member school is a member of the conference, these rights are pledged. What I will say that if somehow ESPN were to kill the deal, because it does look like they have, well, actually, I'm not sure that they can kill it. it may be an opt-in provision as opposed to an opt-out. That's ambiguous to me because of the number of redactions. But if there were to be some way that ESPN could kill the deal, which it would be stupid to do in this sports media rights climate, then that would at least create an ambiguity in the principal GOR that is governing all the intellectual property rights between the member schools and the ACC. It created ambiguity, but would it be successful? Highly unlikely, because it does say that the media rights are pledged to the ACC regardless of whether it's a member of the conference. I'm sorry that language is there, but that does not give people on Twitter, Instagram, whatever the heck it is, to go on and start saying that that the grant of rights agreement is going to go away, it'll be rescinded, and that the teams will be able to go wherever they want. That's not how intellectual property licensing works. Okay, when you transfer an assignment on a patent, you know, the patent holder or the assignee gets to use the patent as the patentee as the patent as he or she sees fit, whether that's creating new drugs from it or generic drugs from it or whatever. When you transfer a copyright, it's the same type of deal where you're transferring the res of the thing, the rights, and the receiver of that copyright gets to exploit it in whatever way he or she wants to for whatever defined term that's in the agreement. And that's how copyright works. And if you're going to have, or intellectual property license work, and if you're going to have one redacted sentence and the linking verb is somehow undo the principal copyright transfer, then you got to have a revision of the Copyright Act itself, which Congress doesn't seem, willing to do. So I do think it's hocus pocus legal analysis. I don't understand it. And I think that's an incredible uphill battle. So, go with it, I guess. I do think it borders on frivolous, though.
Well, and I appreciate the way you laid that out. There's a lot of people, I think, that get confused that they are. I think everybody knows they're separate agreements, but they really like to combine them not into one agreement, but that they can only stand if the other stands, and that's clearly not the case, as you pointed out.
It's preposterous. You got to start with the contract that is at issue. Florida State and Clemson are not a party to the ESPN deal. They're third-party beneficiaries. They are parties to the Grant of Rights Agreement. A judge has got to take the four corners of that document and go back to when it was executed and ask himself, what was the intent of the parties at the time of formation of this agreement?
Right.
Was there the mirror image? Did they have mutual assent? Was everybody agreeing to this? The plain language of the Grant of Rights Agreements clearly indicates that they are pledging their intellectual property to the ACC for exploitation. Yes, it does say for the ACC ESPN agreement, but it also says regardless of the conference. So it could potentially create an ambiguity, therefore giving Clemson and Florida State another avenue to potentially challenge the Grant of Rights Agreement. I don't think it would work because you're going back to the intent of the parties and what they were trying to do at the time of the formation of the agreement. So that's just a masterful construction. Right. I've never seen a court say with the agreement that's before them, say, well, let me go ahead and look at some other agreement for definitional terms. If the parties to the contract wanted definitional terms in that contract, they would have included them at that time. They would have at least referenced the definitional terms in the ACC ESPN deal. So I just think it's a preposterous and borderline, if not completely frivolous argument.
Yeah, and just to maybe close the loop, but close this piece, and then we'll get into a couple other questions I have for you. To me, at a very high level, there's consideration from both sides. The consideration from the members is they're giving their rights away to the ACC.
And there's been performance on both sides.
Right. So all of that has occurred. Yep. And part of the amendments have been to increase the term of this agreement to 2036. And it gets back to what you said before in terms of irregardless of, and this is written in the Grant of Rights, whether a member is an active member or withdraws from the conference, you still have granted your rights to this conference through what we know today to be 2036. I mean, that's the black and white reading of that. And to me, that's cut and dry, but I know obviously people like to try and attack that in other ways. But
well, I think in any other contract, there would be concerns about the length of the deal. If this was a contract to lease a car, or to rent furniture, or to have somebody mow your grass or whatever. You're one of your typical service contracts or something. 20-year agreement with an attorney. I mean, but that's the difference here is that what's at the center of the agreement, and that's intellectual property. Intellectual property just has long lifespans. I mean, look, a copyright lasts for the life of an author plus 70 years. A trademark lasts as long as it's in use. I mean, you can have that indefinitely. A patent is presumptively valid for 20 years, and with potential extensions for enhancements. And a trade secret can go on. Another form of intellectual property can go on forever as long as it's kept secret and is economically viable information. So under the whole scope of copyrights and how long they go, this is actually a pretty reasonable assignment or license, whatever you want. And I think it's absolutely, one of the things that's lost in the discussion is that there is a provision in the Copyright Act that does allow an author to rescind the transfer or the transfer of a copyright after 35 years. So at the very least, 35 years is presumptively valid by statute. So unless you're going to somehow undo the entire purpose of the Federal Copyright Act and what the United States Congress has done, then I don't know how you get around that whole length provision, whatever.
Right. Well, and that's why I really appreciate you coming on our show, David. You are an expert in contract law, IP law, to which copyrights are a part of. So I appreciate that. Let's move to the next question. I want to talk about Judge Cooper a little bit here in Florida. I'm still a little bit confused how and why. Obviously we have Bledsoe that has put a stay on anything that's happening in North Carolina until the appeal process happens and is ruled upon by the Supreme Court there. Conversely, in Florida, Judge Cooper has basically said, we're going to continue on. We're going to have discovery. I think that's underway. The mediation process, everything is just kind of rolling. And he has said he's not going to be putting a stay in Florida for the FSU ACC lawsuits. Is that just kind of up to the judge's discretion, or is there more to it? Should I just kind of let it go and be like, hey, it is what it is? It just seems odd to me that they're two very similar cases, but these judges have taken two very different tacks in terms of how this appeal process is working through a stay or not a stay.
No, you shouldn't let it go. Not at all. I mean, one's been a very organized process that has not, gone over 3-4 days and included 19 hours of hearing. The other one's probably had 7 in the aggregate in 2 cases.
Yeah.
And one has a 74-page order that's been issued in one case, and then a 54-page order that's been issued in the other. I am deeply concerned about the optics of, the case was filed by Florida State, I think on December 22nd or 23rd of 2023.
Right.
They then amended it in January of 2024. There was a motion to dismiss and a motion to stay. Those were not handled in an orderly fashion, and Judge Cooper kind of made up his mind on one thing on the motion to dismiss. He said he granted, bizarre, because on the personal jurisdiction thing, I mean, I was sitting like, come on, ACC. I mean, everybody's going I was not in favor of the ACC prevailing on that notion one bit. Of course, they're subject to the jurisdiction of Florida courts. They have contact coming out of its ears down in Florida. So that was never really an issue. The issue is whether or not it needed to be stayed, in my mind. But the way Judge Cooper handled it is that it sort of issued an initial order and said, let's come back on this after Florida State gets an opportunity to amend. Then he has another hearing, and the ACC files the same jurisdictional challenge. He takes then 56 days to enter the order denying that motion. So now the ACC was forced into a box of having back in, I think it was May have been June, of having to appeal just the motion to stay part,
right?
Which was he entered the order on that.
Right.
But since this whole other part was dangling out in the air, they don't have like a consolidated appeal yet. That was just entered where the Judge Cooper, entered the order denying the ACC's motion to dismiss on personal jurisdiction ground. This is part 2.
Right.
And so because it took so long, they're now having a hearing date that's coming before the Court of Appeals in Florida that's set for I think at the 1st or 2nd, September 11th is when it's set for this year. They just got the order. Now the Court of Appeals doesn't have the benefit of like sort of the second appeal,
Right.
and it's not, getting that brief and record and everything else that would be required. Now, I think that the ACC is represented by a guy named Alan Lawson, Clemson and Florida State grad, that has just impressed me on every level. Now, if he is the sheriff of the appellate bar down there, and if there's a guy who could get it together in short order and get it up to the Court of Appeals, it'd probably be him. I think it would be Sisyphean labor to ask him to do it. So you have that on the one end. They're going to get an incomplete appeal with sort of this like footnote, we're going to come back, right? And then, the way it's proceeded in Florida, everything's up. In fact, Florida State got us record to the North Carolina Supreme Court the other day. It's just been far more orderly. So I don't know, and I'm very hesitant as somebody who's practiced law for as long as I have to be this critical of somebody on the bench. And I'm mindful that the public needs to understand that judges are human and that 95% of the time they're doing what is fair. And if they're not doing what is fair, they're oftentimes doing what they think is fair.
Yeah.
Doesn't mean they're right, but in this instance, I don't understand why it's been as chaotic as it has in Tallahassee. And if you read the ACC's briefs going up to the First District Court of Appeal in Florida, you can kind of sense from them like this is a kangaroo court, or not. I shouldn't say that, but this is some kind of kabuki theater. We're doing the best we can.
Yeah. So I have a quick follow up, David, to that. So we've seen there's such a contrast, sharp contrast, as you laid out, between the very organized method of Judge Bledsoe and the business court in North Carolina versus Judge Cooper's method, where he's got binders everywhere and all that kind of stuff. Do you have any take on was it Pickens County in South Carolina?
Yes.
The court proceedings there, how things are gone. JY and I have thought that basically with Clemson and their suit in Pickens County, that both Clemson and the ACC, they've gotten the kind of the opportunity to look, okay, what worked, in this state, what worked in that state, how do we change our filings? And it seems like things have gone pretty smooth there, because it's their, the third one to go kind of thing. But do you have any thoughts on Pickens County and what's happened there?
Certainly does have that appearance of going smoothly. There's one hearing, didn't last very long. There was an order that was issued comprehensive on all the issues before the court, including jurisdictional contests, and the motion to stay wasn't broken up. And I think it came out within about 3 weeks of the oral hearing. I read Judge Grabbley's opinion. I thought it was really very solid. I thought it was actually on the personal jurisdiction question. I thought Judge Grabbley's analysis was outstanding. On the motion to stay part, not so much. I mean, it actually just didn't really have a whole lot of case law or analysis whatsoever. But it does seem to me that Judge Grabbley, and in addition, and I'll be fair to Judge Cooper, are deeply concerned, and even though I think this is more defensive and not offensive, but are deeply concerned about the issue of sovereign immunity, and that a state entity can only be sued in the state it's in. So Florida State can only be sued in Florida, and Clemson can only be sued in South Carolina. That did come across in both opinions, or Judge Cooper's 2 opinions, and then Judge Grabbley's 1 opinion. But in answer to your principal question, I think it looks smooth to me. Now, whether he got it right is another question for me. I don't think he did. You're probably going to have a follow-up question, about whether this is chaos or not. So I'll go ahead and answer that now.
That's what I was going.
That's the next question.
Yeah, you brought the word up before chaos. I was going right into it. So we've got chaos. Is that going to continue? What is happening?
It absolutely is, and I really want to stress how disappointing I find it to be, because it's going to weaken the confidence in the public's confidence in the judiciary. Because what's going on if and I can't believe how many times I've answered the question, is there a thing as such as home field advantage in these cases. And in any typical world, the answer is no. That's an athletic concept, not a legal one.
Yeah.
But the perception that's going to be built in the minds of the public is that that's exactly what's going on. And so in any, like, it seems like any normal world, why in the world would you have 3 jurisdictions resolving what is almost nearly identical issues involving the Grant of Rights Agreement? And so I think it's terribly unfortunate. It's I'm deeply concerned about the public's, confidence and what their opinion is of the judiciary and how the court system works. Because inevitably, Florida State fans are going to be cheering, yeah, well, we got it. Judge Keeper's keeping it here in Florida, and Clemson fans are going to think the same thing with Pickens County. And so, the reality is, though, that one judge should be handling this and should be treating all the parties, the ACC, Clemson, and Florida State, with complete even-handedness and fairness. That can happen, but when you have things going on in 3 jurisdictions, and let's count here, you have something going on at the first District Court of Appeal in Tallahassee. You have something going on at the trial court in Leon County. You have something going on at the trial court in Pickens County. You will surely have something going on at the South Carolina Court of Appeals in Columbia. You have 2 cases that are pending before the North Carolina Supreme Court, and that's a total of 6 cases, if I counted it correctly, because the matter in Tallahassee hasn't been stayed. And so, technically that's still going on. And I'm sure the appeal in South Carolina by the ACC is imminent. So if that's not the definition of judicial chaos and procedural chaos, I don't know what is.
For sure.
Got another follow-up then. So, David, what do you think is a realistic remedy for that chaos? I mean, I'm envisioning a scenario where you talked about Judge Cooper and the judge in South Carolina, where they're really concerned about sovereign immunity. And we have Judge Bledsoe in North Carolina, who looks at this strictly as a copyright and IP case, as you said. And states are supposed to respect the rulings in other states, but if we were to get a ruling in North Carolina that's just strictly the way you're calling it there, but then in South Carolina or Florida, they say, well, the court in North Carolina didn't pay proper respect to sovereign immunity, or we disagree with the ruling, whatever. I mean, is there a plausible scenario where we have conflicting rulings, and what's a remedy for that?
Well, I think it's a 2-part sort of response. The first thing is, let's put aside questions of filing priority. Okay, who filed first? And when you do that, which is only a factor and it's not dispositive when deciding which jurisdiction should proceed. Okay, that's just a factor. So set that aside. You ask, where did all this happen? Lex loci contractus. Where did all this happen? And where are at the time of the agreement? All that stuff happened in North Carolina. I mean, it's not that I'm trying to be a North Carolina homer or anything like that, but there's no question that the events leading up to the Grant of Rights Agreement back in 2013, which was precipitated by the departure of the University of Maryland, which brought in all the university presidents in North Carolina to discuss what schools to bring on to the ACC, how to bind the ACC together through the Grant of Rights Agreement, where these things were signed. Importantly, who was the last signature to go on it, which I understand was Commissioner Swafford. All these things, where are the witnesses today? Where are the documents today? These kind of things, all of that militates towards North Carolina. Okay. And so, I don't think that Judge Bledsoe has it out for Clemson or Florida State or anything like that. I think he's a jurist that's been on the bench for some 20-some years and has handled complex litigation, and he's completely capable of doing it. That's not to say that Judge Gravely and Judge Cooper are incapable of doing it, but everything sort of militated clearly towards everything proceeding in North Carolina. But to answer your second part of your question, do we have a realistic opportunity of having conflicting judgments? I don't know. to be honest. I'm gonna hold out and say maybe not. I think that, and it goes back to sort of that question of home field advantage, which has me so concerned. Judges can do interesting things. They only decided procedural motions. They didn't get to the core questions of the enforceability of the Grant of Rights Agreement. The arguments that it's actually an exit fee, which is complete horse crap. And some of these other, they could, after getting through these initial phases, look at the actual questions presented, because the question has never been presented because it is an ultimate question of law, and I think it's not a question of fact, but let's just say it's an ultimate question of fact, is whether the Grant of Rights Agreement is enforceable. They have not reached that question, so they may come into and sing like a pretty little chorus line, and all sort of coming to the same conclusions, and the appellate courts and everything else coming to the same conclusions. Obviously, there's always that aspect that they may not, and in all candor, I'm concerned about that now, because we seem to have missed some layups getting out of the gate, and this use of sovereign immunity to possibly escape agreements that these people signed, and that they took hundreds of millions of dollars under. And I mean, you just ask your anybody in your life, your first cousin to somebody you work with, have you ever done an agreement where you signed and you took $100 million under, and then you were like, nah, you know what, I didn't really, I mean, it doesn't work that way, obviously. So I am concerned simply because of some of the initial decisions, which, I also have confidence in the courts of appeals in South Carolina and Florida, and believe that ultimately it may take years, but or months, we don't know, but ultimately I think the court will get it right.
Well, you mentioned Judge Bledsoe a few times. We know now he's going to be retiring the end of this year. Just wanted to get your take as to what that may mean in North Carolina. And as Steve mentioned before, in some states, in some instances, judges may stay on even past their retirement to kind of see a case through. Do you have any idea what may be happening there? Specific to this case, because that's what we're talking about. Like, both in terms of with his retirement, could that cause some issues if he does step down? Not that there isn't another judge that can do just as good of a job, but they got to get up to speed and all that. And I guess second question is, could you see him staying on till the end of this case?
So it's been a while since I've visited this, and I've been in the bulk of my practice is in federal court, and what I can absolutely tell you is that in federal court you can retire and retain some jurisdiction on this or that case.
Okay.
In North Carolina state court, which I'm not in nearly as much, I'm still there, but there is an age limit, but I think that there may be a provision that, so I don't know how old Judge Bledsoe is, so there is an age limit, but I know that there was one Wake County judge involving, his name was Howdy Manning, great judge, loved him, who held on to this Leandro case after he retired. So I assume that it may be possible. I guess I just don't know, but so he may retire and retain jurisdiction somehow. Maybe there's a business court rule that will allow him to do that, or a statute on point. But I think you're right. Even if it's not him, the next judge can come in and get up to speed, actually, in probably very little time. I mean, when you think about the record that's before the Supreme Court right now, it's minuscule. I mean, the pleadings aren't even closed. Florida State hasn't filed an answer. The ACC hasn't filed an answer down in Tallahassee, and hasn't filed an answer in Pickens County. So we've had, and certainly going to be larger because of the amount of hearing times and the transcripts down in Leon County. But there's not been like a ton of, there's not any discovery, there's any and deposition transcripts, whatever. I think a judge could get up to speed on it pretty quickly and not miss a beat.
Okay, well, that's good to hear.
Yeah.
And you've referenced a few things so far. I just want to give you a shout out on what you've report on, or you do some articles and things on X, and maybe you put them on other places. I think you put them on your LinkedIn, some other places as well. And several things that David has mentioned. I mean, he has really, really strong, good write-ups that go through a lot of these different things. You mentioned earlier, I don't know the terminology, contractus, something contractus, or something that you had put out. that I really appreciated. And the last question I'm going to talk about, you just did an article on X regarding this mediation that is going on right now in Florida. I'm not going to go through the article. If people want to see it, check David out on X. I do want to just ask, I mean, I think we all kind of realize no settlements coming out of this mediation. They have to do it. They're doing what they have to do. And if no settlement comes out, like, what does that mean? It just means the mediation failed, and so now they move on with, a trial? Or what does it mean when you come out of mediation going like, yeah, we tried, nothing happened?
Man, I thought you were going to ask me a question about Ashley Moody, the AG down in Florida.
Well, we can get to her at the very end if you want to.
JY is done talking about her. He said he's never talking about her again.
He and I are going to be fast friends once we meet one day. No. The mediation was ordered by Judge Cooper, and, I did have made it clear that in every civil case, mediation is required. And I've never seen it be waived, even though I've wanted it to be. And I think that it is true that 9 out of 10 cases need to be settled, and that the attorneys involved should put their billable hour rate aside and their idea for making whatever money off of it, and settle it based on the facts and the law. In this case, I think it's really hard to do that when you order mediation before the ACC has filed its answer and counterclaim. And it just. I mean, having been a part of scores of mediation, it puts the mediator in a hard position. It puts the parties in a hard position, and so I would suspect that the mediation, according to Yahoo Sports, Ross Dellinger, occurred this past week. So we haven't heard any settlement. Maybe there is one, but I would guess that it was probably pretty quick. Because when you have the kind of case that the ACC has, which is, I think it's pretty clear. Read my article before you flare me up on Twitter, by the way. That the ACC, even the most reasonable-minded Florida State fans could say that the ACC has the stronger hand here. And so and that may be aspirational, what I just said, but they have a stronger hand, and so they may have gone in there, really trying to probe Florida State's strategy with, willingness to go through and participate in good faith, but then looking for the exit once that was done. And when you haven't even filed your answer, you haven't taken the deposition, you've done nothing, and you have as strong as a case as the ACC has, going in there to settle anything for less than the full value of the claim is like folding with a royal flush. Another problem with having the mediation at this stage is that, we're talking about some of the most valuable intellectual property in all of broadcasting at the moment. We're seeing cord cutting, left and right. And you also have what I understand is a direct-to-consumer model that's coming on board sometime in the next 6 months, I think, actually. Maybe actually in the next month. That's a collaboration from Fox, ESPN, and I think one other broadcaster that's escaping me.
Yeah.
And nobody knows the value of these rights. That's going to take some kind of expert testimony looking into the future, or just waiting until the future to see what happens. I mean, whatever they are, they're astronomical. So when you go into a mediation, everybody seems to want to have a number. And the only number I think anybody has that has any certainty to it would be the exit fee, which, as I understand, is 3 times the operating revenue or operating budget of the ACC. So, that's probably around $140 million. But in terms of the media rights going forward and everything else, I mean, you're required to speculate. So I don't know. I would have been personally very frustrated having to do that mediation.
Yeah.
And with as strong as a case, if I were representing the ACC, I would be like, boy, you better come willing to strike a huge check. And for Florida State, if we're representing them, I'd be kind of frustrated too, because I need to know more information and, like, what are the value of these media? I mean, I've got to advise my client, who seems to have an irascible group of people at the board of trustees. I've got to advise them well, and I don't have all the information. So mediation is a great thing. It settles a lot of cases, but I also think some cases deserve a jury. And this case deserves what's called summary judgment, and it needs it as soon as possible.
Yeah, I appreciate that. Well, you brought her up. The last thing I'll just say, if you want to say anything about your friend and mine, AG Moody, we'll let you end with that if you'd like to say anything.
I will say
I don't have much to say. Go ahead.
Okay.
I think David described. I was trying to remember this. I think David may have described her writ of mandamus as a flaming pile of dog poo or something like that, if I remember.
I can't remember. I don't think I would have said that. I do try to present some things. Sometimes I try to be funny, but sometimes, I realize other people are watching or other people are reading. So I don't think I would have done that, but I did describe the material she got back as a pile of as a mountain of redacted crap.
Yeah.
And it was.
Yeah.
But I don't have much of anything to say about AG Moody other than, look at my writings and look at the outcome. The outcome was hilarious to me. I mean, it was hilarious. The fact that she went out and declared on Twitter that she was a public, I mean, I obviously do public records law. I mean, and open meetings and media rights. And, there's some cases down here for which I've done it. And in a public records case, ask the court to not have a hearing and then to avoid one and to get the kind of junk back that she got and go out there and act like a public records hero was truly funny to me. And I think that a lot of people, I think whoever got her involved down in Tallahassee probably regret it. And I think a lot of people agreed with me on that one thing. So I thought it was a true abuse of police powers. And nothing gets my back up kind of like that. So I was relentless on her.
Yeah.
Well, I've seen you mention on Twitter, and we've mentioned on the show, she's a politician. She's making. I think it's clear she's making decisions based on what she thinks is going to help her politically, not necessarily based on, hey, is this a winning legal argument? And politicians have their own interest in mind many times, and especially in a state like Florida, which we don't get into politics in this show, but I think it's important for people to point out, the title of Attorney General of a state carries a lot of weight, and it should. You're the top cop, you're the top lawyer, but at the same time, she's a politician. They're trying to win elections, and if you follow her Twitter, which I do pretty closely, everything is about putting herself in the best light. And I'm not saying that to be derogatory. I mean, again, she's a politician, so she's working for, as she says, working for the taxpayers in the state, but a lot of it is aimed at putting herself in the best light. So to me, that's where the discussion ends. She's a politician. She's not acting to me as a legal, maybe not even acting as an officer of the court in the way she should be, more acting in her own political interests.
Yeah, I disagree with you, Steve. I think that she's Florida's chief legal officer, and as such carries a certain responsibility to enforce the law on a fair and equitable basis, and not to use frivolous, unconstitutional writ of mandamus actions to purportedly get public records. And so that's one thing. The other thing is that I don't think this helped her. So I'm not going to be political at all, but I don't think that it helped her from either side of the aisle, whatever side you're on, because I think it ended up getting the University of Florida upset, the University of Central Florida upset, probably the University of South Florida upset, even though they're not in the Big 12 or one of the other conferences. It was only until that happened, when the Big 12, the SEC, and the Big 10 filed their amicus brief, she started whistling a different tune. And so, even if you look at the federal Justice Department and the AG's office, that is supposedly an apolitical office. I know there's other issues that I won't speak to about that right these days, but she did use her police powers to get at private contracts, and I thought that was an abuse of police powers.
Yeah, I think we're actually in agreement, David, as far as what she should be doing and how she should behave. I think she attempted to do something else, but we're in agreement on
It
how
backfired.
she should behave.
Yeah.
It backfired.
Well, David, we appreciate you coming back on. I know you've cleared up a couple things that I have been wondering. We'll continue to follow this on the Big Mountain. I know we have communication via X every so often as well. We wish you all the best going forward here. And yeah, we're ready for football season. Let's stop talking some legal stuff and let's watch some football here finally. So.
Yeah, that'll be a good distraction, and hopefully we'll get to it. The concern I have is that we won't really get to what's just fun, and we'll be fighting over some of these things and who's right and who's wrong.
For sure.
Well, we definitely follow you religiously on Twitter, and I would say we have a lot of Florida State fans. Anyone interested in this case should be following you. And I think what happens is sometimes if people don't agree with you, they just write you off. Oh, this guy, you know, he's a Duke homer, or North Carolina homer, whatever. But if you are interested in this, I'm speaking to our Florida State fans and all ACC fans and college football fans. If you are interested in the legal ins and outs and you want to have a good understanding of this case, David is one of your number 1, 2, or 3 followers or follows you should be following to actually understand the ins and outs of the case so that you have realistic expectations.
Right.
It's so much fun to follow these accounts that are saying, you know, August 15th, Florida State's out of the ACC. It's going to happen. Well, that didn't happen. Those people were blowing smoke just to get attention. And maybe those Florida State fans should have been paying more attention to you when you broke down some of these legal arguments. So again, that's not a message to you. It's a message to those Florida State fans. And my wrap up is we're following you. We're rooting for you.
Thank you.
You're an awesome guy. And we love having you on. We love talking to you. And we're rooting for you.
Yeah, thank you for doing that. I really do appreciate it, and all love to everybody in Tallahassee. Love you guys. Nothing personal.
Understood. Hey, with that, we thank everybody for watching. Make sure you like this episode. Subscribe if you like our content. Much more to come on all the ACC lawsuits. With that, we'll see you next time on the Big Mountain.